For decades, California's highest court has left it up to individual jurors to decide whether certain circumstances increase the severity of a crime and thereby warrant the death penalty in murder cases that qualify for the ultimate punishment. On Wednesday, the state Supreme Court heard arguments on a change to that long-standing practice, which could potentially overturn hundreds of death penalty sentences in California. At issue is how juries review aggravating factors, such as whether a crime was gang-related or involved multiple victims. Defense lawyers in the case argued that to ensure equal application of the death penalty, state law and the state constitution require juries to be unanimous in their reasoning on each factor. That the court is even considering new requirements is unusual. It has refused to impose them in the past and has even summarily dismissed the kind of arguments presented Wednesday. But the court's composition has changed over the years. Last June, the court issued a brief order asking for written arguments on the jury issue in what was otherwise a routine death penalty case. That raised hopes among some that the court might be ready to wield an axe to capital punishment in California, a state that has produced the nation's largest death row but hardly any executions. Wednesday's hearing probably tempered those hopes. During a 90-minute hearing, only 3 justices, the more liberal members of the 7-judge court, spoke. Though the silence of the majority can be interpreted in different ways, the hearing did not clearly signal that monumental changes were afoot. The June order asked litigants to submit written arguments on this issue. Must a jury decide beyond a reasonable doubt that a defendant should get the death penalty or life without parole? And must that jury also be unanimous in deciding the reasons for a capital verdict? If the court agreed, a ruling would probably throw out hundreds, if not all, previous death sentences in California. The court's sudden interest in the issue alarmed death penalty supporters. They considered the questions long answered. Kent Scheidegger, a lawyer for a prominent pro-death penalty group, said he was both surprised and very disturbed, even with the changed composition of the court. Over the last decade, appointments by Govs, Brown and Gavin Newsom, both opponents of the death penalty, have transformed the court from a moderately conservative forum dominated by former prosecutors to a moderately liberal one. Democratic appointees now hold 5 of the 7 seats. Newsom, moreover, filed written arguments in the case urging the court to take a new path. In a brief written by 2 legal scholars, Newsom assailed the death penalty as racist and cited study after study that found the system discriminated against Black and Latino defendants. Justice Goodwin Liu, a Brown appointee, spoke the most during the hearing.